Just connecting Mr. Lawler here, and he's the only one on Zoom.
He is, okay. That is not what I expected. This phone call's been made to my office.
All right, Mr. Lawler, are you able to hear me okay?
I can, Your Honor.
All right, thank you. We'll go on the record. This is a matter of the foreclosure of certain properties for unpaid property taxes of 2021 and prior years. This is file number 2311396. And if I could just have the folks from the county put your appearances on.
Yes, Your Honor. Charles Lawler, P65164, on behalf of the Crawford County Treasurer, who appears to be sitting in your courtroom.
Kate Wagner, Crawford County Treasurer.
Thank you. And Ms. Wagner, we're on the record here today to enter judgment of foreclosure as to the properties identified in Exhibit A. Is that correct?
That is correct.
Okay. Mr. Lawler, is there anything that you wanted to state for the record?
Is there anybody in the courtroom, Your Honor? We were
yes. Yep, we have two individuals in here.
do we want to handle them first, or do you want me to outline what's been done up to date?
I'd like to have you outline that, and then I'll hear from the folks that are present, and then we'll see where we go from there.
Thank you, Your Honor. Your Honor, we initiated this action with a petition for foreclosure filed on or about June 8th, 2023. What that asked for was to foreclose all properties in Crawford County that had a delinquent 2021 and prior years real property taxes. It also includes interest, penalties, and fees. We then filed an order for hearing, as is required by the statute. And then we didn't really take a lot of action because it's not required, except for all the notices that the treasurer's office did during that time. We filed an amended petition for foreclosure on January 5th that updated the list of parcels that were still subject to foreclosure. Unfortunately, we had to file a correction to that because we normally file our amended petitions in December. So we had to change one word that said prior March 1st forfeitures as opposed to this year's March 1st forfeitures. That was the only difference in the corrected amended petition. Then, in order to fulfill the obligations under the statute, on January 9th, we filed a number of affidavits. We first filed an affidavit of publication stating that all parcels that were subject to foreclosure were published in the Crawford County Avalanche for 2 consecutive weeks. We filed an affidavit of personal service, and what that affidavit provided was that the representative of the treasurer went and visited every parcel that was subject to foreclosure, tried to make contact with a person. If they couldn't make contact with that person, they posted the parcel. We also filed an affidavit of the title search. What this affidavit provided, Your Honor, was it provided that Ms. Wagner's representative did a title search on every parcel that was subject to foreclosure, and then that allowed us the opportunity to identify and notice every person of interest in that parcel. The last affidavit we filed, Your Honor, was an affidavit of service of the notice of show cause and the actual foreclosing. And that was filed by, executed by the treasurer. What I would assert, Your Honor, is based on all the filings we've done and everything else, the treasurer has fully complied with MCL 211.78, and all the parcels are subject to, all the parcels on the attached list are subject to foreclosure if they don't pay the delinquent property taxes, penalties, interest, and fees. By the statute says March 31st, but in this particular year, since March 31st is on a Sunday, they'll have until April 1st to pay. So if you have any other questions, Your Honor, I'm happy to field them. or we can talk to the people in the courtroom.
Okay, I don't have any questions. Sir, can you tell me your name?
Greg Loser?
Okay, and do you have a property that's at issue here?
Yes.
Okay, what would you like to say regarding that property?
I have taxes coming back. We'll be able to pay this with. I'm not positive they're gonna be back in time. I was wondering if I can get an extension on that for a certain amount of days. You know, I have in excess of the amount of the taxes coming back. And I've had several things happen this year that kind of threw wrenches in my ability to pay it before now. But yeah, one being my father dying, of course, big one. But anyhow, yeah, if the court was show the mercy of allowing me a little extra time, just in case if it comes in before that. I'm having trouble with the IP pin. I'm using the IRS's IP pin and it's still rejecting it, so I might have to do it by paper, which they're saying was a 6-week delay. I'm kind of right in the middle of that right now. I might be able to get it resolved. If that happens, I should have it back well before that. I'd have it back by the end of February, and if I do, of course I'll pay it, you know.
Okay, Ms. Wagner or Mr. Lawler, did either of you take any position about this request?
I
Is,
guess I'm gonna say, go ahead, Charlie.
no, go ahead, Kate.
I'm going to do that, but there have been agreements made with this office that have failed. This parcel has also received Michigan Home Assistance Funds to the max that was allowable to take care of the taxes before, and another person had paid the taxes last year to save it. There have been no payments on this property since last year in March. Nothing.
Mr. Welser, the court will give you until June 1st to make payment as to this.
Thank you.
Property. And if you, and
Your Honor.
Mr. Lawler.
Your
Yeah, go
Honor,
ahead.
excuse me for interrupting you, Your Honor. Could we do May 31st since that's a Friday? June 1st is a Saturday.
Yeah, May 31st is fine.
And then the other thing I wanted to point out, Your Honor, is as has been general in the past, we also include a paragraph at the end of the judgment that allows the treasurer to pull parcels if situations like this would come up until the point of the auction without having further action taken by the court. We've done this because Miss Wagner's always been one who wants to just collect the taxes. She doesn't want to take the parcels, and she bends over backwards for people. So rather than us having to trade back to the court all the time, in years past, some of the other judges in this circuit have allowed me to put that paragraph in there, and I think it makes sense in both for the common good of the community and socially. I think it's appropriate anyway.
Yep, I agree. And that allows
Okay.
use of this, Ms. Wagner.
Yeah, I've always done that. I already have people set up on agreements for that are late for this year already. So, you know, because they came to my office at the hearing.
Okay, so we'll just make a record then, Mr. Welser, that May 31st would be.
Yes, sir.
Okay.
Thank you very much.
Sir, are you here to speak on this issue?
I am, Your Honor.
Okay, can you tell me your name, please?
Jeremy David Craig, sir.
Okay. What would you like to say regarding?
I suffered a broken neck, 22nd, August 11th. And I was in healing for about 6-7 months. It's kind of hard to get a job for broken neck. I've since gained a lucrative position at FedEx Ground out of Gaylord. And I intend to pay it this month. I can pay most of it this Saturday, and then I get in 2 weeks. I intend to.
You and I can talk.
Yeah, I'm just panicking. I got a letter. I want to be involved.
Yeah, this is the first time I've met you, so we'll talk after this.
Yeah, I've never gotten this far. You know, I'm just trying to do the right thing.
We'll
Thank you very
talk
much.
after this, after this.
That's all.
You've done the right thing by being here today.
Yes,
You're
sorry.
sure that you can make arrangements.
Excuse my tardiness. I appreciate the court's time.
All right, thank you. Mr. Lawler, that addresses the only individuals that have appeared here in court today. I'll note for the record that no one has tried to join by Zoom either. So based on what you stated in my review of the file prior to the hearing today, the court finds that the county has complied with the statute regarding foreclosure. And one thing I didn't look was to see whether there was, you have to judge. And Mr. Lawler, I'm going to sign that judgment right now.
Okay, Your Honor, can we make sure that the treasurer notates on the exhibit, the first parcel that we gave until May 31st?
Yep, we will do that here.
Thank you, Your Honor.
Your Honor, do I need to do anything else or? am I
You
good
do
on
not,
that?
no, your, what we agreed on today will be written into the judgment.
Yeah, I figured as much. I didn't want to interrupt anything.
No, you're fine.
Thank you, sir. Have a good day.
I appreciate you allowing us to do some of these hearings by Zoom, Your Honor. It becomes quite a cost savings for the treasurer.
It's one of those, things that, as much as the, COVID was unfortunate, kind of forcing everybody to do some of these things by Zoom has been a good thing, because you're right, it saves money, and I think it's more convenient for people a lot of times, so.
So do we do anything else besides this for that May 31st?
Nope, just have to take it over to the clerk and get it entered, and I'm sure you know all that stuff, so.
Okay, I'll go out in the mail here shortly. Thank you, Charlie.
All right, thank you, that concludes our hearing, and you're free to disconnect.
Thank you, Your Honor. Bye,
Of course,
Kate.
next- At 2
Bye, John.
o'clock, we'll be in recess until 2.
This
Yeah. Do you have that?
Yes. Okay, it looks like we have both counsel connected, so we'll go on the record now. This is Swander versus Zavarol. This is case number 2010818. If I could just have both counsel put your appearances on.
Melissa Whitman here for Ryan Zavril.
Good afternoon, Your Honor. Miranda Bailey Quick on behalf of Ellie Swander. She is present in my conference room with me.
All right, and I do want to note, Mr. Zavarol is also connected by Zoom here. If we, I did have a chance to kind of look through the file. It looks like the parties have a hearing before the referee scheduled for next week. So I'm not sure, if there's anything that we need to or want to do today at this hearing. Ms. Bailey Quick, on behalf of plaintiff.
Your Honor, we've actually signed a stipulation. The parties went to mediation. We've reached an agreement for at least the interim time resolving outstanding issues on parenting time. And as far as today's hearing, we've also reached an agreement as far as support. My client has agreed to a reduction of the outstanding arrearages in an effort to resolve this matter. And what we would ask the court, we'll withdraw our motion and request for a show cause for contempt and just ask the court to enter an order certifying the stipulated amount of $15,000 of arrearages. And as part of that agreement, Mr. Zavarol has agreed, and I think the front of the court would naturally do it anyways, but just as part of the agreement is that any tax refunds would be assigned to Ms. Swander until the arrearages are paid in full.
All right, thank you. Ms. Whitman?
Your Honor, Attorney Bailey Quick is correct. We went to mediation and resolved all of the child-related issues at this point, other than child support. We sent her office a stipulated order. I believe it's just come back to me, and she's been kind enough to say she will deliver it as soon as she can. We hope that that will resolve the hearing on the 12th. So that won't need to be anything more than a check-in if it needs to happen at all. We just resolved the child support issue. And yes, we are agreeing to the $15,000 figure for the arrearage and the continued use of the $726 a month as stated in the current order. So the $15,000 will be paid over time. And yes, any tax refunds that Mr. Zavarol is entitled to, those amounts would apply toward the $15,000 until it's paid in full.
All right, thank you. Ms. Robinson, was there anything that you needed to weigh in on?
No, Your Honor.
Okay. All right, so counsel, you're just going to submit an order reflecting these agreements to the court?
We already have a stipulated order entering the custody and parenting time agreement, which has already been signed and will be over to the court soon. And then Ms. Bailey Quick and I can do a stipulated order for the child support issue too.
Okay, great. All right, thank you. That's all I have for today then, and both sides are free to disconnect at this time.
Thank you.
Our next hearing set for 2:30. We'll be in recess until that time.
I don't know how much of that panel case you wanted, so I just grabbed like the last section of it.
That's fine.
Okay, because there's so much.
Yes. All right, I'm just waiting for everybody to get joined in here, so just 1 minute. And it looks like Mr. Graves was having some trouble, so if everybody can just hold on, well, he's gonna try and re-sign in here in a second. Okay, Mr. Barry, are you here on the Hamel versus Munson Healthcare case?
I am, Your Honor, yes.
Oh, okay, great.
I'm with the Handel Esperance firm.
Okay, perfect. All right, we're still waiting for Mr. Graves, so if everybody can just hold on for a minute. Okay, so I just got a message from Mr. Oh, looks like, okay, hold on. I think he's trying again here. Okay, Mr. Graves is still having some problems. He's gonna try and dial in by phone. I do have another hearing to address that was set for 2:30, so I'm just gonna ask all of you to stay on the line and stay muted, and then, I'll call this case just as soon as I can. Okay, Mr. Saxton, if you can, unmute yourself, please.
All right. Good afternoon.
All right. Good afternoon. Are you Anthony Saxton?
Yes, I am.
All right, thank you. And ma'am, on the Galaxy device, are you Hannah Saxton?
Yes, I am.
Okay. All right, we'll go on the record in Saxton versus Saxton. This is case number 2311501. The record should reflect both parties are present today by Zoom video. I have this set for entry of a final judgment of divorce in this case, and I do have a proposed judgment. It looks like both of you signed back on January 21st. As the filing party, Ms. Saxton, is that how you wanted to go forward today?
Yes.
Okay, and Mr. Saxton, is that how you wanted to go forward as well?
Yes.
Okay, I'm gonna place you both under oath. I've got some questions that I need to ask each of you. The questions that I'm gonna be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you both would raise your right hand, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Yes.
Okay, thank you. You can both lower your hands. Ms. Saxton, you filed for divorce in this case and you signed that initial complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In that complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
That's correct.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you would not be receiving or paying any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Correct.
And in terms of dividing up any personal property, the two of you are just going to keep whatever you have in your possession. And then in terms of the house, Mr. Saxton is going to keep the real property and either refinance or sell and pay you half of whatever the equity is after any debt is satisfied.
Yes.
Okay. And other than that, are there any issues regarding the division of any marital assets or debts that require a decision by the court?
No.
All right, thank you. Are you asking to have your last name changed?
No.
Okay. Mr. Saxton, have you heard all the questions that I asked Ms. Saxton?
Yes.
Did you hear all of her answers?
Yes.
Do you have any reason to believe that any of the answers she gave were not true?
No.
You, under the judgment of divorce, you also would not be paying or receiving any spousal support or alimony. You understand that you also would be waiving that forever and that you would not be able to come back later and ask the court for that.
Correct.
And do you agree that you will keep whatever personal property you have in your own possession and that you will keep the real estate, and if you sell it, you will pay half of the equity after any debt is satisfied to Ms. Saxton.
That is correct.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. And I'm going to sign that judgment here today. Ms. Saxton, do you have any questions at all?
No.
Mr. Saxton, do you have any questions?
No.
Okay, if either of you would like to get a copy of the judgment for your records, you can get that here at the clerk's office in Grayling. Otherwise, you're both free to disconnect at this time.
Thank you.
Thank you.
All right, Mr. Graves, are you there?
Yes.
Okay. And looks like all counsel is now connected and rejoining the hearing. So we'll go on the record. This is Hamill versus Munson Healthcare, case number 2111065. We do have all counsel now present. This is set for a status conference in this case today. I know we've had some motion practice, but I guess I want to see where we're at and what we might need to do for scheduling going forward. Mr. Dibb, on behalf of the plaintiff, I'll let you weigh in on that first.
Good afternoon, Your Honor. Albert Dibb appearing on behalf of the plaintiff. I think I can speak for everyone. We are busy scheduling and taking plaintiff expert depositions that are those that have not been taken yet are being scheduled. We've been to I think we went to a facilitation, didn't we?
Yes.
Yeah, we went to a facilitation. We're doing the plaintiff experts. We had requested some time to substitute another previous expert, an emergency medicine expert. And I was going to ask the court if we could get some additional time to secure that expert. Right now we have until February 23rd. And if the court would be inclined to allow us another 30 days.
Okay, all right, thank you. Any defense counsel want to weigh in?
Sure, Judge. Enrico Tucciaroni appearing on behalf of Dr. Eaton, the ER physician who's the experts are being substituted against. I've known Mr. Dibb for a long, long time, and usually I don't have objections, but another 30 days on this. That motion was heard back in December. I think Dr. Salzberg's was withdrawn. He was supposed to be deposed early December. I was looking for the date, but can't find it right offhand real quick. But Dr. Salzberg it was early December. So now we are 2 months past his withdrawal and request to substitute. I think 2 months is plenty of time. I think if he can't get an expert, a new expert by the end of February, that we would object to any addition beyond February 23rd.
All right, thank you. Any other defense counsel?
Steve Berry on behalf of Munson Healthcare, Dr. Leorden, Dr. Lagatuda, Dr. Schubert, and Tammy Milbacher. We just need the deposition of plaintiff's nurse practitioner expert, and then there are a number of causation and damage experts that are listed by plaintiff's counsel, which we need as well. So we need time to get those conducted.
I represent Dr. Atchison, Your Honor. I don't really have anything to add other than to kind of echo Mr. Berry's points.
Okay, Mr. Graves, anything you wanted to add in there?
There's no, Your Honor. We'll just stay mute on this one.
Okay, to each defense counsel, is anyone anticipating any dispositive motions being filed?
Potentially, Your Honor, after expert depositions are completed, especially as to my client, I think there's some significant causation issues.
I agree with that. Once we get the damage and causation experts done, there may be summary disposition motions.
For Huron, for the Houghton ambulance, same here, Your Honor.
And
Okay.
Judge, if I may, I found the date when Dr. Salzberg's deposition was scheduled is originally scheduled for November 20th. So we are now going on almost 3 months since Dr. Salzberg's been withdrawn.
Okay. All right.
But just to
the
that
court-
point, we were not notified until December of Dr. Salzberg's unavailability to be an expert anymore. So while his dep may have been scheduled, we did not know until, I believe it was December. And that's when we notified everybody and filed a motion.
Okay. All right. Well, what I'd like to do then today is number one, address that issue, and then number two, I'd like to set a deadline for the filing of dispositive motions so that we can get those going, get all of those heard and ruled upon. So, Mr. Dibb, I'll give you an extra 30 days, so the court will set the deadline for plaintiffs to identify their new expert as March 31st.
Thank you, Your Honor.
So, and that's going to be a firm deadline. I think that's more than enough time, and you're either going to be able to have somebody by then or you're not. So
Yes.
we'll set that as the date of March 31st. If we have that as the drop dead date for identifying that expert, understanding that the defendants are going to want to depose that expert before you get a dispositive motion filed.
Right.
I'll start, Mr. Tucciaroni, with you. Like, I mean, what would you want to suggest for a cutoff date for and not to be heard, but for the filing of a dispositive motion?
For the filing, I don't remember off the top of my head where we're at on the other causation experts. But I would think if Mr. Dibb gets till March 31st to add an ER doctor, if we can get him deposed by the end of April, probably the end of May for a dispositive motion cut off. So we get the transcripts in, time to get the transcripts in and the briefs filed.
Well, that assumes that we're going to get all of the causation and damage experts done by the end of May. And thus far, it's been like pulling teeth getting dates for experts. So to me, it makes more sense that the discovery or the dispositive motion cutoff would be like the end of July, unless we're provided with dates for experts within the next 60 days so that we can complete them within the next 60 days.
Let me just jump in. It's been pulling teeth because we have to schedule 4, 5, 6 schedules to get an convenient expert dep date. I don't want it to be suggested that plaintiff's been dilatory in producing dates. It's difficult to schedule convenient dates for all of the attorneys involved. So just want to make that clear, Your Honor. And as far as causation experts, I don't know who Mr. Berry is referring to, because I think we've deposed our OB-GYN experts, and these are, and I'm assuming these are referring to retained experts.
Correct.
Yeah.
Yeah.
Because there are other experts in the case, such as the medical examiner, who I did not retain, but who is identified as an expert in this case and did an autopsy, flew in from Florida to do the autopsy. He's an expert. So if the defendants want to take his deposition, they're free to make that arrangement with him directly, because he's not a retained expert as such. But if we're talking about retained experts, we have struggled to get convenient dates for everybody to take these steps.
Okay, so here's what we'll do. The court will set a dispositive motion cutoff date at the end of July. I think that's reasonable, but counsel, just remember, I mean, you can file them at any time between now and then. You don't have to wait until that point. But that would just be like the, you know, the cutoff date where they couldn't be filed after that date. So to the extent that any defendant or the plaintiff is prepared to file a notice for hearing a dispositive motion, they can do that at any time. So I'd be more than happy to hear some or all the motions prior to that, but that'll serve as, again, a cutoff date. And then the court will set this for another status conference at the beginning of August. Assuming that we're going to have some hearings prior to that on motions, or at least have them scheduled. And if we don't, then that status conference would act as a control date where we can address going forward from there. Otherwise, I will set a status conference for a date where we have a motion hearing scheduled. Mr. Dibb, any other dates that we can address for your side today, or is that good for going forward from here?
No, that's good. And I should point out that there has been a dispositive motion already filed in the case that the court has decided, so. At least.
Yeah, wasn't that the economic damage for the baby?
Correct.
That we're referencing out, yeah.
Okay, any defendants need any other dates, or are you guys all good with the way we've got it set going forward from here?
But now that Mr. Tucciarone raises this issue, the issue that was raised in that summary disposition motion regarding the baby's economic projected economic loss is presently that issue is presently before the Michigan Supreme Court, and I don't know when we are expecting a decision on that, but just to let the court know that depending on how the Supreme Court decides it, we may be asking the court to revisit that issue.
Okay. Well, we'll cross that bridge when we come to it.
Yes. I just raised that because Mr. Tucciarone pointed it out.
Sure, okay.
Glad to help.
All right, any other dates for any defense counsel?
No, Your Honor.
Not that I could think of, Your Honor.
No, Your Honor, for here, Houghton EMS.
All right, thank you. So I'll put what we discussed today into an order. I'll also send out a notice for that next scheduling conference in August, and we'll go from there. Thank you. All parties are free to disconnect at this time.
Thank you, Judge.
Thank you, sir.
Judge, can you hear me okay?
Yes, I can. Let's see. Are you,
Judge, can you hear me?
Celeste Conflitti?
Yes, sir, I am.
Okay, and Mr. Vernon, that's your client, is that correct?
Rachel? Nobody can hear me,
Can't hear us.
Yeah.
or they're not talking to me.
I can hear you, Adam.
Why can't I hear them? Celeste, can you hear me?
Yes.
Okay, now I can hear everybody.
Are you able to hear me, Mr. Vernon?
Yes.
Okay. All right, we've got one other party here on a device. Their name isn't filled out, so I don't know who it is. It's a OnePlus device. Whoever signed in on that device, if you can hear me, please turn on your camera and connect your audio. Mr. Vernon, I'm just gonna give this party a minute or two to try to connect here, okay?
Okay,
They're signed in, but they haven't.
I expect that to go on, so.
Yeah. All right, sir, that's connected on the OnePlus device. You need to go into your Zoom app and connect your audio so that we can talk to you. Okay, sir, now I just need you to unmute, please. Okay, can you tell me your, Ken, can you tell me your name, please?
Sure. My name is Bernie Confletti.
Okay, great. Thank you. All right, we're on the record now in Confletti versus Confletti. This is case number 2311528. We have both parties present. We have Mr. Vernon present. On behalf of the plaintiff, all parties are appearing today remotely by Zoom video. This was set for a scheduling conference in this case today. Mr. Vernon, I understand that this is a partition claim. On behalf of the plaintiff, how did you want to proceed in terms of scheduling? Do you have any requests?
I think we can actually make discovery pretty short and then schedule it for mediation. And then if we don't successfully mediate this, then schedule it for a trial. I don't think the facts or the evidence here is real complicated. The parties own a piece of property together that they inherited from their mom's estate. And Mr. Confletti is not agreeing to dispose of the property in a manner consistent with either the will or Ms. Confletti's position. So we're asking the court to, if we can't reach an agreement, order the property be sold and divided accordingly.
All right, thank you. Mr. Confletti, do you have any objection to participating in mediation? That's where you would meet with a neutral third party. They would attempt to facilitate an agreement between you and Ms. Confletti. Neither of you would be required to reach an agreement, but they would try to see if there was any way to do that. Do you have any objection to participating in that process?
No, I don't. But if I can say something, I never did anything to keep my sister from selling that property. What Mr. Vernon said is incorrect. I did not respond to some bad offers, but I've been wondering why my sister hasn't sold this property 2 years ago.
Okay. All right, and I'm not here to make any decisions today. I'm just here to set some dates going forward. And it sounds like maybe the mediation might be a good thing to open up some lines of communication. So the court's going to order that occur within the next 60 days. So the court will refer this to community mediation for that process. So Mr. Confletti, somebody will be in touch with you to set up a date and time that's works with both you and Ms. Confletti, okay?
Sure, thank you.
Okay, Mr. Vernon, anything further that you'd like to request from your side at this time?
No, Your Honor.
Mr. Confletti, did you have any questions at all about how we're going to go forward?
No, but your instructions for Zoom weren't very clear because I was logged in, but nobody told me I had to push any buttons and the mute and unmute thing. I just stumbled upon that.
Yeah, I understand. We send out instructions on how to connect, and then it's kind of up to the parties to know how to use the Zoom software. So
right,
that's why we don't have instructions on that.
Okay, well, yep, no, I'm fine. Tell my sister I said hi.
Okay, sounds good. So I will put this into an order. I'll send that out to the parties, and then we'll go from there. All parties on this case are free to disconnect at this time.
Okay, thank you. Goodbye. All right, how do I disconnect?
All right, Mr. Smith, are you able to hear me okay?
I am. Good afternoon, Your Honor.
All right, good afternoon. We're on the record now in North Branch Outing Club versus Brad Bear. This is case number 23-11495. The record should reflect Mr. Smith is present today by Zoom video on behalf of plaintiff. This hearing was set for 3 o'clock. It's now 3:10. No one has appeared either in person here in the courtroom or in the Zoom waiting room on behalf of the defendant. This was set for a scheduling conference in this case today. In light of the defendant's non-appearance, I don't know if you're expecting that or not, Mr. Smith, but how did you want to go forward here on behalf of plaintiff?
Your Honor, in light of the fact, I mean, he was personally served. An answer was not filed within 21 days. I think it was late filed on the 28th. We had submitted a default judgment originally, but our process server didn't get a copy of the proof of service to the clerk. And by the time the proof arrived, the answer had appeared and the clerk accepted the answer as having been filed timely. In light of, and I'm not surprised that he was improper with his answer. And having been dealing with him for some time now, it was really a stall. I'm not surprised he's not here. In light of the fact that he has failed to appear, we request entry of the default judgment previously submitted.
Okay, all right, I am in receipt of the request for default and the default motion for entry of a default judgment. It is for some certain, so I think under the court rules, it would be appropriate to enter that in light of the late answer filed by Mr. Bear, as well as Mr. Bear's failure to appear for the hearing today. The court notes that he was provided notice of the date and time of today's hearing, which was served on him by the court back on January 3rd. So I do have that proposed judgment, so the court will sign that. Anything else, Mr. Smith, that I can address for your side here today?
Nothing on my end. Appreciate your help, Your Honor.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you, Judge. Appreciate it.
All right, Mr. Potter, can you unmute, please?
Can you hear me?
All right, so, yeah, I can. Is your name Dane Potter?
Yes.
Okay, Mr. Potter, I have this set today for entry of a default judgment of divorce. Is that how you wanted to proceed today?
Yes, sir.
Okay. All right, Mr. Potter, excuse me. We're on the record in Potter versus Potter, case number 23-11323. Mr. Potter is present today by Zoom video. This hearing was set for 3:15. It's now 3:20. The opposing party has not appeared, so we can proceed here today. I also want to note for the record that there was a default entered in this case that Jordan Potter was provided with notice of the date and time of this hearing. However, Jordan Potter has failed to appear, so the court finds that default judgment would be appropriate. Mr. Potter, I'm going to place you under oath. I've got some questions that I need to ask you. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. So if you'd raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Potter, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Yes.
Have you been a resident of Crawford County for at least 10 days?
Yes.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
To your knowledge, is Jordan Potter currently pregnant?
No.
Under the judgment of divorce, you would not be paying or receiving any spousal support or alimony. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Under the judgment of divorce, you would be keeping whatever personal property is currently in your possession and Jordan would keep whatever was in her possession. Is that your understanding?
Yes.
And you don't own any real estate or real property with her?
No.
Okay. All right, based on the testimony of Mr. Potter, the court finds that the statutory grounds for divorce have been met. The court will grant the divorce. I'm signing that judgment with today's date, so your divorce is final. If you'd like to have a copy of this judgment for your records, you can get that here at the clerk's office in Grayling.
Okay.
Did you have any questions at all, Mr. Potter?
Nope, that's it.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
but usually, oh, here we go.
All right, ma'am, can you tell me your name, please? Oh, Miss Lamont, you're gonna have to connect your audio. Mr. Lamont, are you able to hear me okay?
Yes, sir.
Okay,
Are you able to hear me, sir?
I can, thank you.
Yep, no problem.
So Miss Lamont, if you can hear me, you need to connect the audio on your Zoom app, otherwise we're not gonna be able to go forward with the hearing today.
Is she out front?
Hmm.
It almost looks like she's out front.
Okay, now you just need to unmute.
Hello.
Okay, all right, we've got everybody connected now, so we'll go on the record. This is Lamont versus Lamont. I have this set for entry of a judgment of divorce today. Ms. Lamont, is that how you wanted to proceed?
Yes, sir.
Okay, and Mr. Lamont, is that how you wanted to proceed too?
Yes, sir. Thank you.
Okay, and so we need, what do we need from Ms. Lamont?
If possible, for her to state her address on the record for us.
Ms. Lamont, we need to get a current address for you. Can you give us your current address?
7402 Charles Street, Frederick, Michigan, 49733.
Okay, and can you give me a phone number where you could be contacted?
989-370-2718.
Okay,
Thank you.
Thank you. All right, I'm gonna have both of you raise your right hands. I'm gonna swear both of you in, and then I'm gonna ask some questions. These are gonna be the questions I'm required to ask to establish the grounds for divorce under Michigan law. So do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Yes, sir.
Thank you. You can both lower your hands. Ms. Lamont, you're the one who filed for divorce in this case, is that correct?
Yes, sir.
At the time you did that, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
Had you been a resident of Crawford County for at least 10 days?
Yes, sir.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes, sir.
Does that remain true today?
Yes, sir.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, sir.
Are you currently pregnant?
No, sir.
Under the judgment of divorce, you would not be paying or receiving any spousal support or alimony. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes, sir.
Are you asking to have your last name changed?
Yes, sir.
What are you asking to have that changed to?
Day.
DAY?
Yes, sir.
Okay. And you and Mr. Lamont are gonna keep whatever personal property that you currently have in your possession?
Yes, sir.
And you don't own any real estate or real property together?
No, sir.
Okay. Mr. Lamont, did you hear all the questions that I asked Ms. Lamont?
Yes, sir.
Did you hear all of her answers?
Yes, sir.
Do you have any reason to believe that any of the answers she gave were untrue?
Nope.
And you also would not be receiving any alimony or spousal support. You understand that you would be waiving that forever as well, and you would not be able to come back later and ask the court for that?
Yes.
And you've already, you're gonna keep whatever personal property you have in your own possession?
Alrighty.
And do you have any, do you agree that you don't own any real estate together?
Yes.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. I signed the judgment of divorce. If either of you would like a copy of that for your records, you can get that here at the clerk's office in Grayling. Ms. Lamont, because the divorce is final as of today, your name is legally changed as of today, so you may need to get a copy of that judgment so that you can change your identification and other documents, okay?
Yes, sir.
Do you have any questions at all, Ms. Lamont?
No, sir.
Mr. Lamont, do you have any questions?
No, sir. Thank you, Your Honor.
Okay, thank you. That concludes our hearing for today. That also concludes the court's afternoon docket. The court will be in recess.